Good afternoon, sir. Your voice is muted, sir. Rowena ma'am has joined already.
Okay, I can't see her.
Hi, good afternoon. Good afternoon, Professor Talukdar. How are you?
I'm fine. How are you?
All right, we are okay.
Thank you very much for accepting to
No,
deliver the
it's a
talk.
pleasure. It's a pleasure. Thank you for inviting me.
Dr. Saika, he's there or not? Like he's in a separate. He's attending this lecture.
Uh,
Professor Saika.
Maybe. I'm
Yeah,
not
I'm listening. I'm listening from another room to not disturb her.
Okay, all right, all right.
Sorry, Jai, he's already there.
Very good. Okay.
Good afternoon to all of you.
Good to see you.
Good afternoon.
Good.
I think we can start in a few minutes, maybe 1 or 2 more minutes for the people
Sure.
to join.
Sure. Dr. Borwa, all the deans were informed not to
Yes, sir. I informed everyone.
because we had so many meetings today. Maybe that's why maybe it may take few minutes.
Yeah. I again reminded after our last meeting.
Yeah.
Good afternoon, Unisha. Just for you joined. Manas, are you there?
Yes, sir.
I think we should start the proceedings. People will keep on joining.
Okay, sir. Thank you. So good afternoon, one and all present here. Respected Speaker, Madam, Honorable Vice Chancellor, sir, Chairperson, Advisor Research, Dean of Faculties, HODs, and my dear colleagues. On behalf of Assam Downtown University, I would like to welcome you all to the 6th Chancellor Lecture Series. I welcome today's speaker, Dr. Rowena Robinson, Madam. Thank you, Madam, for accepting our request. Before starting the session, I would like to request Professor Sunandan Borwa, sir, to kindly introduce Dr. Rowena Robinson, Madam. Sir.
Thank you, Manas. A warm welcome to Dr. Rowena ma'am and all others who are present here for this lecture. It gives me immense pleasure to introduce Dr. Rowena Robinson. Ma'am is a professor of sociology at the Department of Humanities and Social Sciences, Indian Institute of Technology, Bombay, and has taught earlier at Delhi University and Jawaharlal Nehru University. She was also a visiting professor at IIT Guwahati between 2012 and 2014. She completed her education at Delhi University and Cambridge University in UK. Among other publications, she is the author of Boundaries of Religion, which is published by Oxford University Press in 2013, and editor of Minority Studies, again published by Oxford University Press in 2012. She is co-editor with Marianus Joseph Kuzur of Margins of Faith, Dalit and Tribal Christianity in India, a SAGE publication in 2010. She has also published several journal articles in the areas of constitutional law, education, conflict, Christianity, and issues of gender, caste, and civil society. Dr. Robinson will be speaking on imagining a democracy, fraternity, horizontal rights, and society. I now pass on the platform to Dr. Rowena. Ma'am, it's all yours now.
Thank you very much. And first, thanks to all of you for inviting me and for giving me this opportunity to speak to the faculty of Downtown and staff and students perhaps also of Downtown University. I know that several of you do work in sociology and political science. I think some of the names I came across are Dr. Devika and Dr. Lanu Devi and Dr. Papri and Dr. Suparna and so on. I don't know all your names, sorry. But I hope that some of you will find some interesting thoughts here as well as ideas for empirical research that can come out of work like this. This is actually, I'll just turn off my video here for the slides. This is actually perhaps you could consider it an exercise in historical sociology as well as the sociology of law, so that the data for this these ideas come from historical materials, particularly from an analysis of Constituent Assembly debates from the late 1940s onwards, as well as from an analysis, content analysis of Supreme Court judgments over the last many decades. This has become a little, I would say perhaps not a little, much easier now because these are available online. But, and so they are, there's a wealth of data there that, that can be usefully analyzed. Anyway, let me go then straight to what I want to talk about today, which is fraternity, horizontal rights, and society in the framework of how we imagine and maybe even how we assemble a democracy. How do we assemble ourselves as a democracy? I focus particularly on the idea of fraternity because it is a little bit of an obscure right. Lots has been written about equality and about liberty. And these are the three ideas, the triptych of ideas that came out of the French Revolution and that also inspired the Indian freedom fighters as well as the members of the Constituent Assembly. When we talk about rights, as you in political science will know, we generally talk about both vertical and horizontal rights. And fraternity is a horizontal right. Vertical rights are rights such as equality and liberty, and they involve a relationship, a vertical relationship between the state on the one hand and the individual on the other. So the state treats us as equal before the law, and the state gives to us or recognizes our right to liberty, and that is also a vertical right. And these are therefore easier to conceptualize and to think of and also to implement. On the other hand, fraternity is a very difficult idea to conceptualize as well as to operationalize. It is a horizontal right because it concerns our relationship with each other as co-citizens in a republic. At the same time, we have to ask ourselves, in a democracy, if we deny each other our fundamental rights, how sustainable can we be as a democratic society? Even if this is a difficult idea, there are strains in the discussion on in the Constituent Assembly about fraternity. And various things were said about fraternity in the Constituent Assembly, most notably, of course, by Dr. Ambedkar himself. And I will come to that in a little while. First, let us consider the idea that in making the Indian Constitution, the Constituent Assembly members believed that they were making a transformative constitution. In other words, this was not a conservative document which was just supposed to continue the rule of law as it had been established in colonial British times. Rather, they wanted the constitution to actually transform society by invoking the ideas of liberty, equality, fraternity in a society and at a time when society was very divided. There were caste divisions, gender divisions, class divisions, and regional divisions. At that time, what did it mean to say that we want to transform ourselves, or we want to give to ourselves a society in which we are all equal, a society in which we are all free? So clearly, the Constituent Assembly members thought of the Constitution as a transformative document, which was going to be ahead of society and going to transform society in the direction of liberty, equality, and fraternity. And these were the roots of the idea of the Constitution that were also there when, for instance, in 1946, Jawaharlal Nehru put out the Objectives Resolution, which was accepted by the Constituent Assembly members later on in 1947, which was a solemn resolve to constitute India as a federation of states, guaranteeing the rights that are today in the preamble of our Constitution. We can also understand that this was meant to be a transformative constitution, and it was also accepted like that by the citizens of India, because even as the Constituent Assembly makers were writing out this document and it had actually not been signed, the process for universal suffrage and equal citizenship had begun, and there was this enormous process going on throughout the country to ensure that every citizen was documented in the electoral rolls. Even homeless people should have a right, it was said, to be able to elect their own government, and steps had to be taken in order to ensure that they were also put on the electoral rolls. So this process of actualizing the Constitution, actualizing these ideas which were going to transform society and make India a democracy, were already in place even before the Constitution had been accepted and had become the framework for the new India as took place in 1950. The first elections also then that were held just after that were in effect a referendum on the Constitution, and by the fact that the members of the Constituent Assembly and the Congress at the time came into power in Parliament at that time, is in effect a referendum that the Indian people accepted and gave to themselves this Constitution, this transformative document. Now let's talk a little bit about fraternity. As I said, fraternity is a very vague idea, and what does it mean? Brotherhood, fellowship. It has been used a lot in Christian thought, and because of all these reasons, because it is vague and associated with a particular religion, etc., it is considered a kind of obscure idea, one that is a little doubtful in terms of its implementation in a democratic society. But still, you find that in the Indian Constituent Assemblies, there were several members who talked about fraternity, and they talked about fraternity in relation to caste, for instance. People like Pandit Govind Ballabh Pant, people like Joseph Alban D'Souza, Shankar Rao, B.G. Kher. Apart from Ambedkar, they talked about fraternity. They talked about how there is a need for fraternity among Indian people because of the divisions of religion and the communal atmosphere at the time of of early independence. They talked about class divisions and the division between the haves and the have-nots. And they also talked about caste divisions, the deprivations of the Dalits and the scheduled castes, and how society is divided by caste. Ambedkar particularly talked about political, economic, and social rights, and how these together are the basis for a democratic society. That it is not enough to be a political democracy. It is necessary for us to be also an economic and social democracy. And it's quite noteworthy that Ambedkar spoke so much on the idea of fraternity because he did not speak that much in the Constituent Assembly. He was he was the person who the main person behind this document in its thinking and in framing the Constitution, but actually in the debates themselves, he did not talk and make long speeches, and there were only 2 long speeches, I think, that he makes in the assembly. And this particular one, the last speech that he gave on the 25th of November 1949, this was just before the document was going to be signed and it was going to become the Indian Constitution in early 1950. The Constitution was in effect complete at this point, and people were making their final speeches on this document. And at that point, Ambedkar chose to talk about fraternity, and he said that he was very worried. He said that I don't know if once having got independence, India might lose independence once again. That we may be a democratic society and we may have a democratic constitution, but are we really a democracy in a social sense? Are we really a democracy in an economic sense, given that we have so much poverty and inequality in society? And he also talked about social democracy. What does it mean to have a way of life, not just to have ideas such as liberty, equality, fraternity up there in the Constitution or in the political setup, but on the ground, in society, among relationships between ourselves. And in this last speech, he spent a lot of time talking about this idea of fraternity. And he said, what does fraternity mean? He said it means a sense of common brotherhood of all Indians. And he talked about how difficult it is for Indians to think of themselves as a nation or as a people, because we are divided into thousands and thousands of castes. But he said that if we want to become a nation in reality, then without fraternity, we cannot be a nation. Without fraternity, equality and liberty are also meaningless, and they are no deeper than coats of paint. But what is very interesting is that in the preamble, the phrase that refers to fraternity says assuring fraternity and dignity of the individual and the unity of the nation. And the phrase the unity of the nation comes after dignity of the individual. This is the phrase as it is in the preamble of the Constitution. And there were several members, there were some 5-6 members of the Constituent Assembly who wanted the phrase, this phrase of fraternity in the preamble to be put in a different way. They wanted unity of the nation to be put before the dignity of the individual, instead of the other way around. And I don't know if you know the name of B.N. Rao. B.N. Rao was the legal advisor to the Indian Constituent Assembly, and it was his job to look at all the comments and all the revisions that everybody asked for, and to measure whether any amendments should take place in the Constitution. And B.N. Rao who was charged with vetting all these suggestions, he rejected the proposal. And he argued that the reason for putting the dignity of the individual first is that unless the dignity of the individual is assured, the nation cannot be united. And this is a very important idea for us to remember when we think about what it is that our Constituent Assembly members meant when they talked about fraternity. Fraternity meant first assuring the dignity of the individual. And only then can we assure unity, because only then can we assure that we treat each other with respect. So their understanding of fraternity really turns our attention to thinking not just about the state or the political system as democratic, but about society as democratic, and about asking ourselves, how do we treat each other as co-citizens in a society? And asking ourselves as scholars or as academics that what are the areas of life in which fraternity as a democratic principle becomes important. Just to give you one example out of the myriad of examples possible, I pluck it out really, to talk to you about the costs of not having fraternity in society, the costs that a society has to bear in terms of loss of lives when the state does not value fraternity, and when citizens do not practice fraternity. In some countries of the world, such as England and France, there are something that we call Good Samaritan laws. They are clustered together as Good Samaritan laws. And what these Good Samaritan laws mean is that they provide civil or criminal protection to those who render emergency care in good faith and gratuitously, that is without charge, to anyone they see in an accident or in distress or in a crisis on the road or in a burning house or near the river or anywhere else in a city or elsewhere. You are required by law to provide assistance in accidents, in roadside accidents, etc. And in India, I want to point out to you that a study that was done quite recently in 2013 by the Save Life Foundation showed that we have the highest number of road deaths in the world. And 50% of these fatalities, that is some 35,000 lives per year, could have been saved if attention had been given to these accident victims by the strangers who come along the way in the golden hour when that care would actually save their lives. But we don't do that. In India, it is very rare for strangers and bystanders to assist people, to show fraternity to their fellow citizens, to be good Samaritans, because either legal hassles or fear of repercussions or police questioning or the fact that they will be detained in the hospital, etc. So in other words, not only we ourselves don't feel fraternally obliged to help others, but the state, the organizations of the state, such as the police, as well as other institutions in society, such as the hospitals or the courts, they also penalize. They penalize citizens for showing this fraternity, so that people are willing to let victims die by the roadside rather than help them. And that study actually ended up concluding that the people they had interviewed had argued that India must have Good Samaritan laws. The state must obligate fraternity and it must protect those who offer fraternal assistance to others. So I just gave you this example as one example to point out to you how fraternity saves lives. 35,000 lives a year could be saved if we as a state and a society gave value to the idea of fraternity. Let me move back now to this idea of how do we make ourselves a democratic society? How do we think of our citizens, co-citizens, as neighbors? And in other countries of the world, such as UK, US, France, there are civil law protections in place to ensure that when citizens provide service for other citizens, such as someone runs a school, someone develops a housing society, someone opens a shop or offers some service to the public, that service is offered equally to all citizens. In our own country, we do not yet have equal opportunity laws of this kind, and so there are deep rifts in society when services that citizens open for the public are actually not offered equally to all of us, but there are some gaps and divisions that take place. And in one such case, because of equal opportunity laws relating to education, to equal access to services, to housing, etc., the UK Supreme Court said that it is deeply humiliating and an affront to human dignity to deny someone a service because of that person's race, gender, disability, sexual orientation, or any other protected personal characteristics. And this came out of a case where I think it was a bakery that refused to make a cake of a certain kind for a gay couple. And this case then gave rise to this indictment by the UK Supreme Court. If we humiliate each other as citizens and we deny each other liberty or equality, then can we actually build a democratic society? Ambedkar was very concerned, as I said, with fraternity and with dignity, and I read to you some of what he said in the Constituent Assembly. Shri Jaspat Roy Kapoor made a very interesting intervention in Constituent Assembly debates regarding what has now become Article 26A of the Constitution, which gives every religious denomination or section thereof the right to maintain and establish institutions for religious and charitable purposes. And he actually said that, if we allow citizens to establish charitable institutions only for their own people, and to deny them to others, then this is an idea that is repugnant to fraternity. And it is still in the Constitution, but it is limited by other kinds of values. And Ambedkar, given his concern about fraternity, he was very, his hand is very obvious. His hand is very obvious in this article, Article 15.2 of the Constitution, which says that no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, places of public entertainment, etc. This word, access to shops, it becomes very important. Look at the Supreme Court judgments on fraternity and how they used this phrase, access to shops, to talk about equalizing access to education. Even in private institutions, even in private run colleges and private run institutions, and I'll come to that in a little while. So let's talk about the Supreme Court and fraternity. Trawling through judgments of the Supreme Court over the last many decades, searching for this term fraternity and if it comes up in any judgments and what it refers to, one finds actually only 4 or 5 key judgments in which the idea of fraternity is brought up in what the judges have to say. And 2 of these relate to caste and class. The Indira Sahni judgment on reservations, which came out in 1992, it talked about how in the case of extreme caste disabilities and inequalities, we must think about the preamble and the idea of fraternity assuring the individual, the dignity of the individual. And they talk about how unity, and both unity of the nation as well as fraternity, are unattainable if there are huge substantive inequalities among people. Formal equality before the law is meaningless if people are too poor, for instance, to access the law. So poverty and social and economic disadvantage are substantive inequalities that make a mockery of formal equality before the law. And that judgment also saw a strong connection between equality, fraternity, and the reservation policies, by connecting these through actual social, economic, and political justice on the ground through the reservation policy. Ganpat Rao is an important judgment. Many of these are from the 1990s onwards. These judgment, it's a 1993 judgment. It is against the retained verses that were allotted to the little chiefs and kings and so on, royal families. And in that, the Supreme Court said that fraternity is a basic objective of the preamble of the Constitution, and it took the line of it and it argued that in a country with so many disruptive forces of regionalism, communalism, linguism, the unity and integrity of India can be preserved by a spirit of brotherhood. India has one common citizenship, and citizens should feel that they are Indians first, irrespective of any other basis. And given this background, there is no legitimacy to continue the privileges and the privy purses. So those two were judgments related to caste and to class inequalities. But the other two judgments where one can find fraternity relate to religious and tribal communities. The S.R. Bommai judgment is a very important. It was a judgment with regard to the article that is to proclaim President's Law, Article 356, to proclaim President's Law and to dissolve assemblies. And we know that they are often used by the central government, and this judgment was against that. And in this judgment, also reference secularism, and it is argued that even though secularism was not in the Constitution, it is one of the basic features, and it is part of the structure of the Constitution. And it connects secularism with fraternity by saying that India has always been a society of many faiths, castes, and cultures that have existed together because of tolerance and fraternity. So that, in other words, fraternity is seen as being prior to secularism, but secularism is also the bastion on which one builds fraternity within the framework of India's democratic policy to achieve the dignity of the individual, as well as amity and harmonious relationships among groups. So it sees, like the preamble, fraternity as basic to national integration, and it argues that the rule of law is the chosen instrument to promote all of these. And so dissolving assemblies arbitrary grounds is against the rule of law, and therefore against both secularism and fraternity. A recent judgment, more recent judgment in 2011, Nandini Sundar versus the state of Chhattisgarh, which is on the Salwa Jurung forces that were set up to fight militant groups in the state of Chhattisgarh. And in this, actually, this judgment is quite important because it relies very much more than the others on the idea of fraternity. And the Supreme Court said that fraternity is a separate constitutional principle, and that it is the state's duty to protect against internal disturbances, so that the state cannot say that you need to protect yourself against others in society. And so you need to arm yourself against those others. That is abdicating of its responsibility. And the state cannot turn one set of citizens against another set of citizens. And therefore, fraternity, the Salva Jurum, is unconstitutional, and fraternity is placed within a stronger context of both human rights and human dignity, and invoking the ideas of social justice as well as the development of tribal communities and the like. So these are the critical judgments that we find in relation to fraternity in Supreme Court constitutional law. Now, there is also a few other judgments, including, of course, the Indra Sahni case, where the court talks about educational spaces. And it makes a strong argument that educational spaces, such as whether in the public sphere or in the private sphere, are spaces for the practice and the augmentation or enhancement of fraternity, as well as feelings of unity and nationalism. So there was a very interesting case in 2009, which was the Indian Medical Association versus the Government of India. And in this case, a private educational institution, that is the Army College of Medical Sciences in the National Capital Territory of Delhi, it wanted to open a college in which it would only admit the students who were children of army personnel. And it's so strange that this should be obviously seen as unconstitutional, but this was actually set up, and it got all the permissions from the Delhi government and so on, and it was up and running. And then finally someone went to the Supreme Court, and this judgment was passed. And in this judgment, the court said that education is a public good, and it used Ambedkar's Article 15(2). It extended the meaning of the word shop, and it argued that in effect, an educational institution is a service in the way that a shop offers a service to its clients. So it argued that an educational institution is effectively offering a service to the public. It is a public good, and it used Article 15(2) to say that non-minority institutions cannot reserve seats in an unconstitutional way, and they must further the reservation policies of the state. So in making this argument, it said that universities are a site for fraternity, and it linked fraternity to diversity, and said that a diverse student body enables scholars to interact, to learn about the diversities in life and in society, and this enhances the learning environment for all students. In fact, they say that it is an essential component of the environment of the university in which all students from diverse backgrounds come to study. So we see that in law, in the Supreme Court, the law has actually taken up this idea of fraternity in some interesting ways, but somehow Ambedkar's notion of fraternity goes further, and it goes from beyond just the domain of education, for instance, to embrace all aspects of social life. And if you look at Ambedkar's other writings, you will find that he talks about fraternity as a mode of associated living, of conjoint communicated experience. And in answer to the question then, where do you find this conjoint experience of living together in a society. He says these are in the vital processes of life. It is in the sharing of joys and sorrows of birth, marriage, death, food. That is, if we share food with each other, if we are neighbors to each other and we share in the joys and sorrows of life with each other, in the birth of children, in the marriages, when somebody dies, if we are together with each other in these everyday activities of life in a society, then we can say that we have actualized fraternity. So for him, fraternity goes very deep into society and social relationships in order to fight the prejudices and the humiliations of caste and of religion, including of the fact that we don't marry outside the caste, we don't marry outside the religion, so that we are closed circles of marriage. And then how can we share in each other's joys of life if we live in very bounded groups? So this is very much part of Ambedkar's vision that the interdictions on intermarriage and interdining are inimical to the growth of fraternal feelings in society. Let's anyway ask ourselves, going by what the Supreme Court had talked about in the IMA or the Indian Medical Association case, let's ask ourselves, how are we doing fraternity-wise? Let's look at our educational spaces. And if we look at the research on that, which I've summarized all in one slide here, we see that so much research has now shown that in our schools in different states, Dalits are separated by certain markers. They are made to sit separately. In one state, they were made to wear colored wristbands to distinguish them from other students. In many schools across the country, many schools across the country, Dalits are forced to clean up the school after the studies, or they are forced to clean the toilets of the school. And the so-called upper caste school children will boycott lunches when the food has been cooked by Dalit cooks. So we see that caste is rife. It is open and bare and exposed in our schools where our young children are being educated. If we look at our universities, in the last few years, we have seen no less than 18 or more suicides by Dalit students because of the trauma of discrimination. Some of those have come from our highest educational institutions, including our IITs. Upper caste students, research has shown they have a hatred and an antagonism for Dalits and scheduled tribes. And they believe they are being denied those seats, and Dalits and scheduled tribes are taking up reserved seats that should actually go to them. These students are shamed as being quota students. Their abilities, their competencies are mocked. In IIT Madras, no less, we had the case of a Muslim student who had no friends, and she ended up committing suicide. We also have the staggering indictment that is left to us by the Rohit Behlula case, a student who experienced such terrible loneliness, lack of trust, lack of fraternity, and indignity of social discrimination. And he wrote in a university which is supposed to be a space of liberal and fraternal values, that I always wanted to be a writer of science like Carl Sagan. I loved science. I loved stars and nature. But then I loved people, without knowing that people have long since divorced from nature. Our feelings are second-handed. Our love is constructed. The value of a man is reduced to his immediate identity and nearest possibility. Never was a man treated as a mind, as a glorious thing made up of stardust. My birth is my fatal accident. I can never recover from my childhood loneliness, the unappreciated child from my past. I am not hurt at this moment. I am not sad. I am just empty. This is a staggering indictment of us as a democratic society and a failure of fraternity. In contemporary India, if even one student in a university has to write like this, we have failed Ambedkar, and we have failed as friends, as fraternal citizens, and indeed even as a democracy. But let us go to another area of social life, neighborliness and residential spaces. And remember, Ambedkar, again, that the idea of fraternity is primarily a mode of associated living, of conjoint communicated experiences that are there in the vital processes of life and the sharing of experiences of joy, of birth and marriage and death, and their joys and sorrows in the area of commensality and the exchange of food. Residential spaces are hugely segregated in India, and housing discrimination is a huge area in which very little research has been done in our own country. But we find that what research is available shows us that Indian residential spaces in urban India, as well as in rural India, where from times immemorial, Dalits have been made to stay on the margins of villages. And residential spaces in India have been segregated on the lines of caste and religion, and also to class. And housing discrimination, residential spaces discrimination, and ghettoization impact people's everyday lives. So you still have Hindu-only housing complexes. You have projects that are meant only for Brahmins. Now, how has law dealt with this issue? If we look at constitutional courts of the United States and in Canada, there have been various cases. There the Shelley versus Kramer case is very well known in the United States, when the Kramers actually put a case against an African-American couple, the Shelleys, to try to prevent them from buying property in a white neighborhood. And the court said that the white people who had agreed not to sell to African Americans, this is an agreement between citizens. It is a private agreement, and it cannot be enforced by the state, particularly because the state has to protect the Constitution. The state has to make sure that constitutional rights are not abrogated. So the state refused to protect that right of the whites to only sell to whites. And this became a very important case that is quoted throughout the world now. In Canada, there was the Drummond Wren case, where residential unity, it is argued, is meant to combat separations of religion, of ethnicity, and it is a moral duty of the state to ensure that such fissiparous tendencies which would imperil national unity are prevented. And the Supreme Court said, nothing can be more calculated to create and deepen divisions between existing religious and ethnic groups if there is a method of land transfer which permits segregation and confinement of particular groups to particular business or residential areas and excludes other groups from them. Now, in our own case, there is only one key case that went to the Supreme Court in 2005. This judgment came out, but it is a very unsatisfactory judgment, and it was a two-judge bench judgment, excuse me, and it related actually to the Parsis. The Parsis, being a minority group and protected by Article 29 of the Constitution, with regard to the protection of their language and their cultural rights, etc. The Supreme Court actually argued that yes, they have a right to run a cooperative where only Parsis can buy property, and this is not a very good test case, and the Supreme Court's judgment is very wanting in this regard. In fact, particularly because in India and in elsewhere, the most severe and persistent problem of housing discrimination does not arise in cases of minority groups. It arises when a dominant group, such as in different countries, such as the whites, for instance, they exclude or do not include historically marginalized groups, such as African Americans, Muslims, Jews, Dalit Bahujan castes, etc. On the other hand, if we just look at the domain of law, there was a judgment from the Delhi High Court in 2012, which was far more progressive, and that was the Delhi Dayal Bagh Cooperative Society case. It is a move towards fraternity, I would argue, because this was a housing society that sought to limit its membership to the Radhaswami sect. And in this case, the Delhi Cooperative Housing Society Act argues that the first principle of cooperation is that it must be voluntary and it must be open, and everyone who, irrespective of caste, color, creed, gender, etc., must be able to join such societies if they are capable of using their services and accepting the responsibilities of membership. And so it said that Dayal Bagh Society cannot frame bylaws which go against these principles, and so it cannot create an exclusion. And it referred to the Shelley and Kramer case, and it said that discriminatory covenants are not enforceable by the law. And when you have made a housing society for the purpose of housing, then it is not for the purpose of religion, it is not for the purpose of caste or community or something. The main purpose is housing, and therefore it cannot be restricted on the basis of religion. So this is a move within the legal domain. But it's not enough if we rely on just the courts doing the work of fraternity. We also have to think about how we can expand the domain of fraternity so that we are not reliant on particular judgments. Anyway, since in this case my data was comparative law and judgments from different countries, I'm looking at that here. And there is a South African case. South Africa, you know, a society that is deeply divided by race and suffered from apartheid. And there is this particular 2010 judgment of the South African Constitutional Court, which invalidated a racially restrictive testament, a racially restrictive law. And it did that by invoking the constitutional values of equality and non-discrimination. And it said that these values have a radiating effect, so that they can be invoked not only against state-sanctioned discrimination, but also private acts. I hope you're understanding what is happening here, because in India, when we think about equality and we think about liberty, equality means equality by the state, equality of each citizen in relation to the laws of the state and in relation to what the state does. But if we live in a society where each of us is denying equality to each other, that is horizontally rather than on the vertical plane, we are denying equality to each other, then we are actually denying democracy. And this is what the South African judgment is saying. It is saying that when you put equality in the constitution, it doesn't mean only equality against the state. It also means when private citizens in private acts are denying each other equality, then constitutional law has a radiating effect, and constitutional values have a radiating effect and they can be invoked against such inequalities. India is very divided when it comes to residential spaces, as I said, but this is an area of research that very little research has been done in India. There has been a great deal of research in the rest of the world, where economists, sociologists, and anthropologists and others have done a lot of research. And I think this is an area of research, empirical research, that is just waiting to be explored. But some of the research, my own research, for instance, as well as this Naveen Bharati and his group, he is a kind of economist, social scientist. His group, our research shows that the neighborhood in which you grow up, it has major impacts on your lifetime success and achievements. And if you grow up in a residentially segregated neighborhood, then that aggravates existing socio-economic inequalities, and it eventually leads to violence. You know, people believe that residential segregation prevents violence because we live with our own kind and we don't meet people who are different from us, and therefore there is now less violence between groups. But that's not really the case. And studies across the world have shown that residential segregation eventually leads to more violence. One, because it sows the seeds of enmity, because we grow up demonizing the other. And these seeds of enmity are sown very deeply in young minds. We don't learn about the other cultures. We are separated from them. We don't share in their joys of living and birth and marriage and death, as Ambedkar said. And as happens, the research has shown, particularly with Dalits and Muslims in India, we end up demonizing each other. In urban India, the slums are mainly composed of Dalits and Muslims. Diversity, whether in the classroom, certainly broadens the understanding of society and ultimately of oneself. But if we don't have diverse neighborhoods, then we are sowing the seeds of long-term conflict and long-term violence. And ultimately, that is very costly also in economic terms, because the costs of maintaining these divisions puts a real burden, economic burden on society. It also leads to a lack of social trust. And when there is a lack of social trust in society, that also becomes a burden, a societal and economic burden. So as I said, Ambedkar would argue that diversity in educational institutions is not enough if socioeconomic inequalities and deep-seated hatreds are sown in early life due to residential segregation. And we will end up with neighborhoods like this, with tall walls and fences and abandoned neighborhoods because of violence and conflict and barriers and wires and boundaries. And this is very costly. This is very costly to maintain. It also means that you have to avoid such neighborhoods. So your transportation costs, your efforts increase because you have to take different routes in order to avoid such neighborhoods. And it doesn't reduce violence, because all that happens is that you, on the boundaries of such neighborhoods, the place where two boundaries meet, those become the site for violence. Those become the site for conflict. And so residential segregation in the long term is a very costly burden on democratic societies and is highly avoidable. In other words, I want to just leave with these final thoughts that there can be no democracy without horizontal rights, without horizontal solidarity or fraternity. Equality and liberty are definitely not enough. Political rights, like Ambedkar said, are not enough without social and economic rights. And political and social scientists need to research fraternity more closely rather than only liberty and equality. If we are allowed to discriminate against each other in employment, in provision of services, in housing spaces, this is not only a failure of fraternity, but ultimately it's a failure of liberty and equality themselves. They violate, these divisions violate the dignity of the individual. And therefore, I don't think that fraternity is a vague thing and it is unimplementable. Really, it is an essential basis to the rights of liberty and equality. Other countries have now put in place extensive non-discrimination legislation, such as I pointed out to you in the US, in France, in UK, in Canada, even in a country of the global south, a deeply divided, racialized society, such as South Africa. And there is a need for India to think about such a non-discrimination bill or equal opportunities legislation. Article 15.2 is a basis for such non-discrimination, but it depends on the courts and it depends on a particular case that goes to the court. And so we need to move this activity from the courts to the legislature itself and promote equal opportunity legislation. In Delhi, an equal opportunities bill was framed, but it has not yet reached the stage of legislation. More recently, such a bill has been introduced in Kerala, and we have to see what happens over there. On the other hand, we have an opposite case in Gujarat, where the Disturbed Areas Act actually amounts to state-sanctioned segregation on the same basis as the Salva Judum initiative. The state actually sanctions communities and ensures that they live separately from each other and that they do not sell property to people of other religions. That is on the grounds that there is violence in civil society. But we have already seen that violence in civil society is a state responsibility. The state has to prevent violence, but the state cannot say that people have to protect themselves from each other, and the state also cannot say that you have to live apart from each other because we cannot protect you. If we do that, then where are we? Whither are we in terms of imagining and assembling a democracy as visualized by Ambedkar? We are very far from that. I'll stop sharing now. And if you have buses to catch and all that, but if there are any quick questions, then I'll be happy to take them. Thank you very much. Thank you for your patience and for listening.
Thank you very much, Madam, for the wonderful presentation